Okay, so we're going to go ahead and get started. So welcome everyone. My name is Nathan Silverstein. I'm the founder and president of the Polish Club, the University of Texas at Austin. Today, club officer Annabella Ninomia has the honor of introducing Professor Suchocka. Annabella, take it away.
Hello, everyone. My name is Annabella Ninomia. I'm a Polish club officer and a Polish American student at UT. Today's event is being hosted by the Polish Club at UT, a registered student organization. This is not an event sponsored by the University of Texas at Austin. The views expressed today are of the invited guest speaker and do not represent the views of the student organization, the university, or its officers. This event is being recorded and will be posted on the Polish Club's website, where we have a virtual library with recordings of all of our past guest speakers. I would like to thank our co-sponsors, UT Center for Russian, Eastern European, and Eurasian Studies, the Center for European Studies, Liberal Arts Honors, Texas Global, the Department of Government, the Department of International Relations and Government, and the Strauss Center for International Security and Law. I would like to give a special thank you to Mr. Adam Dominski of the Lech Wałęsa Institute for connecting the club with Professor Suchocka. I'm excited to introduce today's guest speaker, Professor Hanna Suchocka. Professor Suchocka was born in Pleszew, Poland. She started her career as a researcher at the University of Poznań, but was fired when she refused to join the Communist Party. She then served as a legal advisor to the anti-communist Solidarity movement. After the fall of communism, Professor Suchocka became the first female prime minister of Poland and served in that role from 1992 to 1993. Then, from 1997 to 2000, Professor Suchocka served as the Minister of Justice and Prosecutor General. From 2000 to 2013, she served as the Polish ambassador to the Holy See. She currently serves as the chair of the Constitutional Law Department at the Adam Mickiewicz University. She is also the honorary president of the Venice Commission, as a subsidiary body of the Council of Europe that advises member states on constitutional matters and is a democratic watchdog. Today, Professor Suchocka will be delivering a speech entitled Evolution of Constitutionalism in Poland. She will then take moderated audience Q&A for the remaining time. It is my great honor to now welcome a leading Polish stateswoman and intellectual, Professor Hanna Suchocka.
Thank you so much. Thank you so much for the presentation. But as I said, I have a bit problem with the voice, my own voice, not the voice of computer, because I am unable to concentrate myself on the speech because I'm always hearing a double voice. So it is very, very, very complicated, very difficult. So I am very sorry, but probably it would not this how to take kind of presentation I would like to do. So for that reason, first of all, I would like to say something that I would like to say some more words on constitutional heritage in Poland. That's mean constitutional heritage in Poland. Because when we started this our constitution making process after the transformation in 1990, we decided to make a new constitution, but also look at the models which we can follow in our work and analyze from the perspective of a kind of heritage. I think that we have to take into account heritage, constitutional heritage in a double sense. First, the common European heritage, and the second, as a constitutional heritage of our own country. Because when we started, as I said, with our constitution making process, we had to take into account those that we as Poland strongly rooted in the European constitutionalism, and on the other, we also have our own constitutional tradition. As you know, Poland was the first country in Europe which had a written constitution. It was the constitution of the second 8 years of 17th century, 91. It was the first constitution after the American one, and it was before the French constitution. So we can say that exactly Poland was very strongly rooted in such a constitutional thinking in our history. And then for many, for more than 100 century, the Poland was under revolution, and we were under the three different countries. So for that, we didn't have a constitution. But then, after the First World War, we also started to create our new constitution. And then we had two constitutions between First and Second World War. It was the constitution, March constitutions from 1921, and then the second constitution from 1935. So as we can see, exactly the evolution of constitutionalism of Poland was very strong because we started at the end of the 19th century, then we had this break because we know our statehood, and then at the beginning of the 20th century, we started with the two constitutions. Then after the Second World War was also a constitutional regime, and in the constitutional regime, we had a so-called real socialism constitution. But the real socialism constitution did not belong to the European tradition, did not belong to the European heritage, because it was built on completely different principles, on completely different rules, and not the rules which are typical for the European heritage. And then, even after 1989, we could again started with our thinking on the new constitution. And we started with our work on the new constitution since the beginning of the transformation. What was our main goal? Our main goal was to build a constitution which is very well rooted in our tradition, but also the European tradition. We also have to guarantee the main European principle of the constitution. It means, generally speaking, separation of power, pluralism, independence of judiciary. There was, of course, the dignity of human person. There was the main principle, and then main, how to say, it is a fundamental basis for making our constitution. And but when we decided our work in the constitutional commission or committees in Polish Parliament, I was a member for many years, since 1989, since 1997. We looked also for the best model for our future constitution. We, of course, as I said, took from our heritage, constitution heritage, but we also looked for the solutions which exist and exist in democratic countries like the United Kingdom, France, and United States. One of the problems we had discussed, and we discussed very strongly, was the situation between parliament and the president executive power. It was one of the issue very strongly discussed because there were two different models, as we know. It was the possibility to create a parliamentary system or presidential, semi-presidential system. So in our tradition, Polish tradition, we also have these two models because the period between First and Second World War, as I said, we had two constitutions, and the two constitutions were different. They were based on different principles. The first constitution from March 1921 was built on the purely parliamentary system. And the constitutions from 1935 was built much more on the semi-presidential system, yes, with much stronger role of president than a typical classical parliamentary system. And then when in 1989 we started, as I said, our discussion on the future constitution, we always had to decide what kind of way we have to follow. We're going towards the parliamentary system or towards the semi-presidential system. They were different, how to say, thinking, different discussions, various discussions. And finally, we decided to go to the very, how to say, mixed system. We call now as a parliamentary rationalized system. Because what we created, what we established in our constitution, that we have a president which is elected in general elections, like in presidential system, but we have also very strong parliament with a very strong role of prime minister, which such a role of prime minister does not exist in purely presidential system. Uh, we also try to make the role of government much stronger, and so for that reason, we took some elements from the German constitution, which so-called constructive motion of non-confidence towards the prime minister. So as you see, it created a system which is exactly to some extent complicated, and sometimes it could create a tension between different institutions, because you have a president elected in general election, but not having power, like a president in general election in the United States. Then we have a government with constructive motion of non-confidence, but also with very strong role of the parliament. So it is our, as we are discussing on the evolution of the constitutional in Poland, we also had to take into account the very, to say, rich way leading our constitution. We finally passed, adopted in 1997. And then the fundamental principle in our constitution from 1997. Finally, we have, as I said, the constitution. What the fundamental principles are. The Poland is a state of rule of law, or maybe state government law. The very strong principle of the separation of power, political pluralism, guaranteed human rights, and independence of the judiciary. It is exactly how to say core pillars of our constitutional system. And on this pillars, we put all the mechanisms, institutions which allow to keep the power in balance. But as you know, in all systems, it is always possible that sometimes there are some, how to say, um, um, as I said, changes in the system based on the political situation. Because one of the elements of our system, our constitutionalism, was also the certain balance between governing parties and opposition. But it is not written clearly in the constitution. It is written in the, how to say, constitutional culture, political culture. And this relationship preserves political life. And sometimes we can observe that here in this we have some weakness, and they lead to such a controversies, and even, how to say, diminish the role of the constitutional institution. So, saying generally in this my short introduction on the evolution of constitutionalism in Poland, I would like to point out that what is important for saying that we have exactly a strong idea of constitutionalism in the country. First of all, the constitution, the clear principle of the constitution, but then, as I said, very, how to say, well-established political culture and political and constitutional culture. But it, how to say, needs a time. So for the reason we didn't have till now so much time to create a very strong constitutional culture, legal culture, and it is still our challenge for the future, when we would like to, how to say, involve and when we would like to build stronger constitutionalism in Poland. So I think that it would be enough for my introduction. And now we can start with questions and answer as it has been proposed by you on your letter. Thank you so much. But it was very appropriate for me to to make the lecture with this voice in my, to say that. Thank you so much.
Thank you very much, Professor Suchocka. Maybe try turning your phone off. That might reduce the echo.
No.
So do you want to try doing that or no?
What?
To turn your phone off. It
When
might,
I don't have my telephone is off.
okay. All right.
My
Well, then
telephone
we'll proceed as best as we can. So the first question is, Poland was the first country in Europe to ratify a constitution and the second country in the world to ratify a constitution after only the US. How has the constitution that Poland ratified in 1791, referred to as the May 3rd Constitution, established a tradition of constitutionalism in Poland, if at all?
No, I just said in my introduction that it was the first constitution, but as you know, we established our first constitution, we passed our first constitution in the 1791, but then we had the revolution of Poland, and the constitution practically was not the constitution of the state. It was a very important document, very important, how to say, model for us, but it was not the, how to say, living constitution, yes, because it was such a political situation then in the country, but because that's the first constitution in our country, it was the beginning of our constitutionalism, as I said. We have more than 200 years long tradition of constitutionalism, but with certain breaks, I said, yes, because it was not such a, how to say, long line of the evolution, like, for example, United States. Because first of all, we had the break when we were in the partition between Prussia, Russia, and Austria, and then we had the break when we were under communist regime. So it was a different type of constitutionalism and the constitutional regime than in democratic countries.
Right. So yeah, before I proceed to the next question, I just want to apologize if I ask questions that you might have already addressed in your introductory speech, just because it was a little difficult to hear you. So,
Yes,
so I might be asking questions that you already answered, and so I apologize if I do that. It's just it was a little difficult to hear you. So
I have myself very well, because probably the voice went to me, not to you.
potentially, yes. So at least one of us hears you. So to continue with Polish constitutional history, what were some of the aspects of the Stalinist constitution that made life so miserable under communism in Poland?
You know what? As I said, in the communism in Poland, it was not only in Poland, but also in all communist real social states, that we have specific types of the constitution with a specific how to say, rules, specific principes. They were completely controversy to the democratic European principle of the constitution. For example, the principle, well, recognition of the will of the state as essential to creating, for example, individual freedom. It was complete rejection of the personalistic concept. Then, non-acceptance of the concept of human rights based on inalienable human dignity. All rights and freedoms were understood as given state, yes, not as how to say, rooted in the kind of natural law. Then the leading of one single party. It was also lack of pluralism, completely lack of pluralism, and rejection of this separation of powers as a consequence of the principle of one leading party. yes, because the one leading party kept everything, yes, in the hands. So it was no possibility for the separation of powers because the separation of powers in such a system was completely artificial. So we live in such a system for more than 40 years, and then in 1989 we had to create a system that was built on completely different principles.
Right. Okay. Professor Suchocka, would you want to try like leaving the meeting and joining again? Maybe that'll take care of the echo. Or would you rather just proceed as we are?
No, but what I don't hear you well. As you don't hear me well, I also don't hear you well. So
I'm asking if you would like to leave the meeting and then join again, and that might
I
take
tried.
care of the echo.
I
Yeah?
tried. They will not. I tried. So I'm leaving. I'm leaving.
So would you like to try leaving or no? Okay. Let's just proceed how we
Not a
are.
second. I try to leave it.
Okay.
Could you hear me now?
Yeah, I can hear you.
Hello? Okay.
Is it better?
I hope. Maybe.
Okay. So the next question, what do you see as the greatest strength of the current Polish constitution?
Oh, you know, it is greatest strength. Yes. I think that, in my opinion, it is exactly a very good constitution, as I said, which is a constitution which is open towards the future. It is exactly built on the real European and traditional constitution, traditional democratic principles. In my opinion, the constitution creates a very good basis for well functioning of the state. But as we know also very well, that the constitution is not enough because it should be also a will of the political organs, of the political power to fulfill, to implement the constitution. Because constitution only creates a basis for a functioning of the state, and it's always possibility that the organs, that the political power can, how to say, abuse the constitution. And then, even having a very good constitution, there is always possibility to abuse, but by different interpretation of the constitution. As you know it very well, you have a very long tradition in United States. You have the constitution uh, as long as our constitution from May 1791. And you know also it very well in how different way the United States Constitution were interpreted in the history. If you compare the interpretation coming from the period before Roosevelt, after Roosevelt, and even now, yes. So the Constitution is always very important instrument. It is a very, very important document, but it is also a very important instrument in the hands of courts. In your case, in the hands of Supreme Court, in our situation, in the hands of courts and Constitutional Court. And in my opinion, it was exactly one of the very positive elements of our Constitution that we created instruments and elements for keeping separation of powers in this Constitution. But then the interpretations done by political power must be in line with the, how to say, spirit of the constitution. When it is going against, then we can see some, how to say, no deviation in implementation of the constitution.
Thank you. Also, I want to let you know that we can hear you loud and clear now. So excellent.
Yes, it's now better. Me too.
Okay, I'm so glad.
So
So
we lost plenty of time.
Unfortunately, but we were able to understand some of what you were saying. So regarding free speech, the Polish constitution bans certain forms of extreme political expression, listing among these, quote, Nazism, end quote, and fascism, quote, end quote. How does the Polish constitution balance prohibiting extremist politics with protecting free speech?
You know, this is exactly a very interesting point. But as I said in the beginning, that our constitution, was written with such a, how to say, with our experience, negative experience in communist time. So for that reason, you can find in our constitution such provisions, such regulations, which are not, how to say, included in the constitutions of other countries, especially on well-established democratic countries. And for that reason, as you ask me, why we put this special provision as articles and 11 and then article 13, yes, which are concerning the pluralism and the prohibition on creating the parties which are built on fascism, communism, and all the negative symptoms we had in our part of Europe. So for that reason, it is not going against the freedom of speech, but it is only going against the negative phenomena, negative, how to say, I can say phenomena, especially in the process of creation of political parties, which are based on such rules which are coming from fascism, from communism, from Nazism. So it is how to say expression. This article, this regulation is expression of our negative experience we had in the past. And you can find more such provisions in our constitution, which are kind of a reaction to the previous system, because we would like to keep the system on a democratic way. And it was such a conviction that when we put such a provision to the constitution, it could help to keep our constitution on a really democratic way.
Thank you. A related question is about hate speech. In Poland, hate speech is not protected by the Constitution. How has Poland found that punishing hate speech has affected the national discourse, if at all?
The hate speech is not only a problem of Poland, it's not only a problem of the Polish constitution, because in my opinion, the hate speech is now one of the main problems existing in many democratic countries. And I see, because I participate in many international meetings, and I see, for example, that on many forums, the problem of hate speech is one of the crucial, how we can deal with the hate speech, especially in mass media, especially in social media, because it is now one of the important problem, not to, how to say, as you said, not to kill the freedom of expression. So we are looking for the same solution which are typical for other democratic countries when as concerns the hate speech. We have some regulations in our penal code. They are, how to say, regulated by penal code. But then everybody has a right to go to the court and receive the decision of the court, and even go to Strasbourg, to the European Court of Human Rights for the final decision. And we also have such a decision coming from the court in Strasbourg concerning the balance between freedom of speech and the how to say, not the rule not to exaggerate the hate speech, but it is not a problem which is easy to be solved, yes, in one day. So it is a problem which is still under discussion. I can tell you that now, just 2 weeks ago, I took part in the meeting on the in the United Nations on the racial discrimination, and one of the crucial points in the discussion was the problem how we can fight against hate speech concerning the racial discrimination. So as we see in different fields, the hate speech is one of the crucial problems, and it is also our problem. Only by one provision of the Constitution, it is not possible to solve the so complicated issues, which is a complicated issue in political life, but also in social life of many countries.
Thank you. Regarding economics, Poland's constitution enshrines a social market economy as the economic system of the country. Why did the framers believe it was necessary to address economic matters in the constitution?
It is also one of the crucial issue. You know, I wrote several articles on this issue because you know, you also have to take into account the genesis, I can say, the history of our constitution. The transformation in Poland, which started in 1989, was possible because of the role of trade union. And as we well, trade union solidarity. Yes, we know it very well that trade union is a part of the very wide notion economy. Yes, because it's connected with the economic system. So for that reason, we looked for the guarantees which could be included to the constitution to keep certain balance between completely free, how to say, liberal economy and the economy which has this social phase. And so for that reason, you can find such a formulation in our constitution. It was a strong tension in the debate on the new constitution, strong tensions between the, how to say, representatives of pure liberal economy, free liberal economy, and the representatives of the solidarity unions, members who represented much more social part of the economy. So for that reason, we put to our constitution such a formulation that in our country we have social market economy, to point out that it is free market because it's a market. The word market is used in the constitution, but that it should be taken into account in the implementation of the provision social, how to say, interest also. Yes, the how to guarantee in the best way the social needs of society. And we even make an important change in our constitution, because before in the constitutions from socialist, so-called socialist constitution, we have an even special chapter on the economic system in the in Polish political system. And now in the constitutions of 1997, we don't have such a special chapter. We have only some rules in the general chapter on res publica, because this is the title of the first chapter of our constitution. As you know, we follow in this regulation exams of some other European countries, like for example Germany. Germany has also such a formulations. Yes, social market economy, rule of law, freedom of economy, but also social market economy. So we were strongly convinced that some regulations concerning economy should be also included to the constitution, because we make our constitution not in 18th, even 19th century, but we make our constitution for the first 21st century. And so for that reason, we need much more guarantees even on concerning economy and social rights.
Thank you. Regarding the separation of church and state, the Polish constitution calls for the separation of church and state. However, the Polish government also signed a concordat with the Holy See in 1993. Are the two not mutually exclusive?
No, I can say that completely not, because we have, as we called it, we have friendly separation. It is very often used such a formula in our language, friendly separation between state and church. But even better, in the translation of Article 25 of the Constitution, and translation of the article from the concordate between Poland and the Holy See, is that we have to guarantee the autonomy for both institutions, for church and for the state. So they are independent, they have autonomy, but on the other side, they had to cooperate for the common good. And so for that reason, this formula that we have this independence of two institutions, but that they had to cooperate for the common good, is completely in line to have and to accept the concordate, because concordate, our Polish concordate, is built on the general acts of International Act of Human Rights, and they are built on the guarantee of rights of individual rights to belief, to religion, and so for that reason we don't see such a controversy between the general statement of independent state and church and such an institution like concordate, which would guarantee also the cooperation between two institutions for, as I said, for the common good of individuals in the state.
Thank you. Turning now to the EU. In order to join the EU, countries often acknowledge that EU law supersedes national law. However, the Polish constitution states that the constitution is the supreme law of the land. How can these two contradictory realities coexist?
This is a problem which is now one of the very strongly discussed in our reality, but not only in our reality, but also in the reality of of other countries. For example, we can say here, we can show here some decision taken by the Constitution Court in Germany and in some other countries. And the Constitution is, of course, the highest legal act in the Polish system. But we also have to take into account, and we have to preserve the European Union law. And we have to make it is always such a, how to say, need to make, when we see, or the judge will see, that is a kind of maybe not controversy, but maybe a differences between European law and constitution. It is always such a way for looking for the pro-constitutional interpretation. It is one of the instruments in the hands of judges. And then, if not, we have to look for such a construction which help us to keep this interpretation of the European treaties in line with the Constitution. Of course, it was also a decision taken by the Constitutional Court in Poland that in some situation where this is impossible to be done, then maybe we have to change the constitution to be in line with European law. But it is one of the crucial problems discussed now, and it is discussed under the very general title, constitutional identity. Yes, what does mean and how we can see our constitutional identity in Poland in the light of European constitutional identity. How we can keep, how to say, very coherent system, not only in one country, but in the whole Europe. And as probably you know, there are some also proposals done by different lawyers, representatives of different countries, how and which mechanism should be found to guarantee and to make a better guarantees for keeping the European law in line with the national constitutions. So it was proposed then by Professor Weiler and others to even create a second group, a second chamber in the court to look for the best solution in case when such a, how to say, tension could occur. So, but it is always a dynamic process which is now under observation, and we have to how to say implement and look for the best way how to solve it in practice.
Thank you. You've now mentioned multiple times different courts in Poland, which leads to the question, why did the framers of the Constitution decide that a constitutional tribunal would have the power of judicial review, which is the power to decide whether a law is constitutional, and not the Supreme Court?
You know, you put me so many questions, and each of the question was a separate part of our very strong constitutional discussions in the past, and even now, because you know, we in Poland we established a constitutional court before the transformation, because we established the Constitutional Court in late 80s, 86, 87. It was established the Polish Constitutional Court. So then when we started with the transformation process, we just had the institution as a Constitutional Court. Of course, because we started with the all questions, the all, how to say, areas were open. So we started also with a very long discussion concerning what should be the role of the Constitutional Court in the new situation. And maybe, as you put the question, that maybe we have to give more power to the Supreme Court. But having the Constitutional Court before we entered to the transformation, formally to the transformation, we decided to keep this model, which is a model typical for many European countries. As I said, yes, Germany, Austria, we followed the Kelsenian model of Austria in this solution that we had a Constitutional Court, not Supreme Court. I can tell you that now, when we have such a strong discussion concerning the role of constitutional court in Poland, etc., since 2015-16, now there are such voices that maybe we have to rethink our idea on the Constitutional Court, and maybe to give power to the Supreme Court. As I told you, all options are open. We had a very strong tradition of the Constitutional Court, and this is a common tradition for many European countries. All post-communist European countries created Constitutional Court. It is rather common model for Europe, not Supreme Court. But we can agree that both models are, how to say, in line with democracy, with democratic system. It depends on the transition, and it depends on the will of political power, what solution would be the best for the given countries. And we agreed, we decided that the best solution would be to have a constitutional court. And so for that reason, we keep the institution. But as I said, now we can hear much more voices that maybe we have to rethink the situation, but not reject them now, but maybe to find the new solution. But it is a typical, as I said, it is a common solution to have a constitutional court in European countries. When you would analyze the constitution, the European countries, majority of European countries has a constitutional court, not Supreme Court empowered with making the control of the constitutionality. So it was also our way, one of the first in this part of Europe.
Thank you. Whereas the power of judicial review is separated from the Supreme Court, interestingly, in Poland, the Minister of Justice is also the Public Prosecutor General, which you would know very well since you served one time as both of those both of those positions. Do you think these positions should be held by one person as they currently are, or do you think they should be separated into two positions?
You know, it is also a very complicated question, where it's not a very easy answer. Because, you know, I will always go back to my introduction, which I said at the beginning, that it depends on the political and especially legal culture. When there is a very strong legal culture, the role of prosecutor general could be, how to say, combined with the role of minister of justice. But there should be a certain conditions to fulfill such a role. For example, the minister of justice, being a prosecutor general, should not have a power to, how to say, initiate the individual cases, should not have the power to enter into concrete case. It should be only such a general view and general control played by Minister of Justice and Prosecutor General. When I was a Minister of Justice and Prosecutor General, I had no power to initiate or to, how to say, analyze concrete cases. It always had been done by professional prosecutors, not by myself as a political body. And now the situation is more complicated because now the Prosecutor General and Minister of Justice has much stronger power, even to recall President of the courts and even to open the cases, disciplinary cases. So in this situation, I think that the role of Minister of Justice should be limited. When you would like to keep two positions in one, how to say, body, in one person, the competences and the power of Minister of Justice or Prosecutor General should not be so wide, should be much more limited. But now, I was always, I can say, because it's my personal view, I was always of the opinion that it was not a bad solution to keep Minister of Justice and Prosecutor General in one hand. Yes, but now when I see that the power was to some extent exaggerated, I think that the better solution for the future would be probably to separate the two institutions. Yes, so for the future, it would be probably better. But as you know, having this how to say solution in Polish system, we follow the example of United States, where you have Attorney General, which is not Minister of Justice, yes, and also Attorney General. But in our system, it was not completely, how to say, well introduced and well built like it is in American system. And as I said, in American system, it is a long history, a long legal culture, and in our system, we probably have to build it in a different way.
Thank you very much. Final two questions, and these are kind of broader questions. The Constitution enshrines many rights that seem self-evident, such as the right for parents to raise their children how they see fit. Why did the framers choose to explicitly enumerate all the rights people have instead of listing all the rights that the government has and then saying that all the rights not explicitly granted to the government belong to the people, similar to what the US did with its 9th and 10th Amendments?
But you know, in your constitution, as I said, your constitution was adopted in completely different period. Yes, now as we know, we have a very, very wide catalog of human rights, citizen rights, and we have a completely new system of regulation of the human rights. And also, when we made our constitution, we would like to have in the constitution a kind of, how to say, human rights charter. And it is this chapter on the human rights is a kind of human rights charter. And we would like to regulate the human rights in much more detailed ways in our constitution. It is also, how to say, a common experience of many post-communist countries, and even not the constitution which are or were passed in the beginning of 90s. It was a kind of guarantees against the previous system. So we would like clearly stated that this and this right are constitutional right and should be always preserved and guaranteed by state. So it was this idea built on the new, how to say, concept of the new idea of human rights. Of course, when we compare, for example, not only United States, but the French Constitution with Polish Constitution, we see how the French Constitution, the rights are exactly very limited, yes? But now in the new Constitution, which were adopted in the late of 90s, the catalog of human rights should be much wider than it was before.
Final question, which is a question about democracy. The Constitution decided many issues for the Polish people, such as by declaring that there would be publicly funded healthcare for all and setting a relative kind of blueprint for an economic system. Those are just a few examples. Why didn't the Constitution leave more matters to be democratically decided by the people through their elected representatives?
In my opinion, there are also many questions which are decided by democratically elected bodies. But we created our catalog of human rights, taking into account, as I said, the covenant on human rights, yes, covenant on political rights and covenant on the economic, social, and cultural rights. And we would like to have and to keep our catalog much more in line with the international covenants. So for that reason, the regulations are so detailed. And then also the question, because some formulations in our constitution, they have a very general character as concerns these issues, and they can be seen as a kind, as you said, maybe a program for the state, yes, programmatic norms. But some of them are exactly a character of real social rights, which should be guaranteed by the state, and in different way, maybe than the political rights, but also should have a real guarantee. So we now prepared this chapter on human rights, and this provision you mentioned in line with our international obligation as signatories of the International Pact of Economic, Social, and Cultural Rights. It was our idea. I can fully agree that now the constitutions are much more detailed than the constitution 100 years ago or even 50 years ago. But because now we have so many also international documents, we are also so detailed, we have to follow to some extent the solution. I even can, how to say, suppose that maybe when we change, or maybe when in the future we'll amend our constitution, maybe the provisions will be more details even than now. So it is probably such a tendency now in constitutional making process.
Okay. Well, thank you very much, Professor Suchocka. I apologize for the first half of the meeting's technical difficulties, but the second half was so action-packed and full of information and your insightful knowledge that it feels like we had a whole hour full of a great conversation. So it's been an honor to have you on. Thank you very much.
Thank you so much. And I'm also very sorry for the difficulties we had in the beginning. Yes, we lost the time, but finally we found a common language and common voice. Thank you so much. Thank you so
Thank you
much.
very
All the
much.
best. Bye bye. Thank you. Bye bye.